You're good to go. Right there. You're good.
All right. Good afternoon. Thank you for joining us. I'm Deb Neuman, President and CEO of the Bangor Region Chamber of Commerce, and I'm hanging out in my office. See, I'm so good at this with my headphones. Anne-Marie Storey is joining us from Rudman, Winchell. Good afternoon, Anne-Marie.
Good afternoon, everybody.
And behind the scenes, Shelley Sund is producing our first ever Zoom Facebook Live seminar. Karen Sichters is also there in the background helping us out. If you've joined us before, you know that prior to this, we have held this seminar together in a room, practicing good distancing. And given how things are evolving, we felt that it was best to move this to online and separate ourselves completely from each other. But we felt that it was really important to continue having this conversation with you. Many of you have questions about employment law, about your business, about your employees. And who best to answer those questions than Anne-Marie Storey with Rudman Winchell. And look at how thick your notebook is.
That's only part of it too. It's overwhelming.
Every day and every week, I think we're all just trying to take it day by day and do all the things that we need to be doing to distance ourselves and protect our health and the health of each other. And employers are trying to figure out the best practices in this current situation that is unfolding rapidly, and we have no playbook. We're figuring out as we go. I know I've had some of you email me with questions. Anne-Marie, I know you're getting questions. Why don't we start by just having you give us an overview of where we are and what are some of the topics that you're receiving the most questions about?
Well, so maybe I can start because I have 4 updates for you just since since Friday. So, and I think we've sent out separate email blasts about most of these, but just so everybody's on the same page. So the first thing, and one of the most important, is that the notice was published by the DOL. That I'm holding up. We had sent this out by email on our email list. It's on the DOL website. Every employer must have this posted as of April 1. So if you don't have it, you can go directly to the DOL website and print it off. You don't have to buy it. It doesn't have to look pretty. It can be this size, black and white, but it must be posted, accessible to all employees. Now, what we talked about last week when this first came out is that it can also, since a lot of us now are remote, posting it isn't necessarily going to do any good. So employers are encouraged to send it out by email or put it on their internet site. However your employees are accessing information related to their work is how you should get this out to them. So I would post it anyway in the workplace just because, but I would also be sure to send it out in a format that people can get if they're not coming into the office. So that's number one. The second thing is, we talked along when this first happened that the DOL, in creating the Families First Act, was going to give employers a period of amnesty so that if there were mistakes in the way leave was given or not given, there would be a sort of a window for employers to figure it out before they were facing penalties and charges and all that business. So we have some clarification about that, and the DOL has confirmed they will, with a twist. So rather than the 30 days that the DOL initially said we're going to give people as amnesty, well, it turns out that that's true, except that that ran from the date it was issued, which was March 17, except that the act doesn't go into effect until April 1. So as a practical matter, what that means is you only have until about April 17 for the window, as opposed to a full 30 days. I don't know if that was an oversight or what that was, or if they'll revise that once it becomes more clear. But as it stands right now, there's basically a 16 or 17-day window where if you do make a mistake in administering some of this, they're not going to jump right on you with penalties. And my guess is even after that, there's going to be some leeway just because this is so complicated and hard to administer. But we know at least through the 17th, there's a window of opportunity. What does have to happen, though, is first of all, the violation cannot be intentional or willful. And the other thing is the language is the employer quickly makes things right and pledges not to break the law again. So generally good advice for anything, but applicable here as well. Now, who's to say what interpretation is correct is a whole different issue, because as everybody knows, there are a lot of terms and statements in the law that are not defined and that remain a little bit unclear or subject to interpretation. So I'm not sure whose interpretation controls if the employee does raise an issue, but at the very least, the employer ought to show that they responded and considered and made a decision as to what they were going to do. So that's number 2. I'm going to skip what I had down as number 3 and leave it for the last thing, because that's where all the questions are, because it's about the new regulations that the DOL just issued on Friday, interpreting the Families First Act. So at the risk of really irritating everybody, I am, and we sent a blast about this in the worst possible timing. The main DOL, and I'm sure it wasn't purposeful, I'm sure there are deadlines they have to comply with to do this, but the main DOL issued its proposed rules for the paid leave law that goes into effect 1/1/21 that has absolutely nothing to do with any of this other stuff we've been talking about. This is the paid leave law that we all thought was important after the legislation came into effect in September. And we talked on and on about how there was a lot of areas that lacked clarity and you couldn't really write a policy because a lot of the stuff was so unclear. So these are some of the rules that we have been waiting for from the DOL. They do not clarify everything. In fact, there's still a lot of unanswered questions. My advice generally is that we're all so overwhelmed with the immediate situation that this could probably just sort of go on the back burner until the summertime, and then policies can be revised in accordance with this at that point, once hopefully we're through the rest of this situation that we're in. So, but I want everybody to know it's out there because they have been issued. So then the last thing, of course, is that these new regulations have now come out. They do answer or address a lot of the questions that people have been asking. I'm still getting through them. I don't have a complete understanding of them yet because they are brand new, but I will do my best to sort of raise some issues and answer some questions based on them. I also want to say, at the risk of putting myself out there to do this, I have been trying to come up with sort of a cheat sheet for all of our employers who are desperately looking for one. I'm going to just show it quickly. I'm getting there. And because I want to be sure, obviously, that it's accurate, that it's complete. It can't answer everything, obviously, but it at least gives sort of a summary of what all the reasons for leave are, what's the rate of pay I have to give, those immediate questions. And so as soon as that is finished, we will send it to you, Deb, and it can be disseminated on the website and to whoever wants it.
Oh, that would be awesome. Thank you for doing that. You have until 4 o'clock this afternoon, and I'll expect, just kidding.
Oh, right, okay. Today hasn't been anxiety provoking.
Oh my God. Well, in all seriousness, this is really helpful, and it would be helpful to have that. I know DOL is trying really hard to compile all of the information in one easily understandable, readable document. And if you go to the DOL website, you can find that, and we can post a link to that after the seminar. Shelley might be able to pull that up, actually. But we're all just trying to compile this information and as best as possible as it continues to come out. I appreciated the amnesty piece. I think those of us who are employers are just trying to do the right thing, and it's unclear what the right thing is,
Right.
given this circumstance. So knowing that we have some time to figure it out, I will be on a call with the commissioner of DOL this week, so I can run that question by her and see if we can get any more clarity around the time frame.
Well, and don't forget, this is federal DOL, so Maine may not be able to tell you anything. And
Okay.
the other thing that impacts this is the whole small business loan situation. Because, and I'm still trying to work my way through that, but that has a direct impact on whether employers actually decide to lay off or not lay off.
Right.
So somehow they're going to have to, and we're working, I mean, everybody is dealing with the same situation about now, because we all got ready to do all these layoffs and deal with the leave situation. And now some of that may have changed. So I guess everybody's going to have to just factor that in.
Wait and see. We've got some questions coming in, Anne-Marie. I received one in my email this week, and I know you've addressed this before, but it's still a concern. Businesses that are operating, this business may have, if we believe that we may have an employee who has tested positive, or they've been exposed to a family member who has tested positive, what's our best practice as a business in terms of, what do we do?
So I'm assuming the employee came to the employer to say either I think I might be, or I have a family member who is, and I've been within exposure to them.
Right.
I think probably, at least for that person, the best practice would be to have them self-quarantine for the 14 days, even if they don't actually have it or have any symptoms. Where you go from there is a little bit up in the air. I think at the very least, as a matter of doing the right thing, I think employers probably should ask that person whom they have come into contact with, and assuming that folks are still in the workplace and they're not already remote. And if that person has come into contact with other employees, I think it's probably the right thing to do to let those employees know. But if they're not experiencing symptoms and the person who said they might have been exposed isn't experiencing symptoms, it's anyone's guess as to whether or not those individuals, those sort of the next step, need to self-quarantine or not. But I think they should at least be given the option. One of the concerns, and we've talked about this before, is you can't tell the name of the person who thinks they may have been exposed. So that's why the CDC says you have to ask that person who they have been around, and that's how you get the information to pass on to those people. So instead of going to the office and just announcing, Sarah says she was exposed, everybody who's worked with Sarah needs to know that. You can't let them know who that person is. So in a small workplace, as a practical matter, I was just talking to an employer today who had somebody who may now be positive but doesn't know for sure. The workplace is small enough that every single person there has been in proximity to this person. This person's no longer in the office. It's very apparent who they're talking about. But what the employer has to do is say, there is an employee who is not here at the moment who may have been exposed. Anybody who's been in contact with that person may either want to be tested themselves or at least be aware of symptoms. And
How do we, go ahead.
And if somebody says, wow, I'm really worried about that, I don't want to be here anymore, I don't know what they've touched, I don't know, I think that's when you figure out what is the policy going to be about. Are we going to allow you to take leave? Does it fall within one of the categories under the sick leave or the family leave? And if it doesn't, will we still allow you to take an unpaid leave if that's what you choose to do?
I think many employers are just concerned about a potential lawsuit, Anne-Marie.
Yeah.
If I get sick on the job from this and you didn't protect me when there was another employee who tested positive, that's That's a real fear.
Well, and there's a lot of answers to that. I mean, number one, how is anybody ever going to show that the exposure occurred in one place and not another place?
Right.
So, I mean, other than healthcare workers where it may be obvious, if I'm in a regular office setting, I could just get it here just as easily as I could get it at the grocery store. If there was proof or overwhelming, probability that I got it in my workplace, and again, I'm not talking about healthcare workers now, then you're looking at a possible workers' compensation claim. So in that case, there wouldn't be any liability for a civil suit against the employer because it would be workers' comp. But in bring a workers' comp, to be successful in a workers' comp case, the employee has the burden of showing that the exposure occurred at work and not somewhere else. So that's going to be, a hard question to answer in many situations. Now, having said all that, again, OSHA, and we talked about this in the very beginning, has a general duty clause that requires an employer to take steps to keep people reasonably safe. So I would never, ever suggest that an employer ignore a situation where somebody came and said, well, I may have been exposed. You can't just sweep it under the rug and say, oh, geez, well, unless anybody has symptoms, we're just going to keep on keeping on. I think an employer has to react in an appropriate way and make people, in these situations, I think probably more information is better than less.
Right.
Let people make their own decisions unless there's, and again, you got to go back to what the CDC says about whether or not you have some responsibility beyond that to make people leave the workplace or to shut it down.
Speaking of healthcare workers, Anne-Marie, we've had several questions related to our healthcare workers exempt. Have you heard anything about healthcare organizations being exempt from the Emergency FMLA or the Emergency Paid Sick Leave Act?
Yeah, well, because that's what the act says, and there is a little bit of information in the regulations about that just came out. What it does is, so it says that a healthcare provider or emergency responder can be excluded by the employer from the paid sick leave and the expanded Family Medical Leave Acts. I presume the idea to that is that those people are so important that they're not going to let them leave, which, let everybody decide what they think of that on their own. But what this does is only define healthcare provider and emergency responder. It doesn't really give any more information than that about what steps you take to exclude them or what that means as a practical matter, or what if the person's really sick and they just simply can't be there, or they've been diagnosed. So my best guess at this point is that if an employee came, somebody defined as a healthcare provider and said, I want to take leave because my kid is not in school and I fall under that provision, technically under the law, the employer could deny that leave. But I'm not sure how that works as a practical matter if the employee is saying, now I'm really torn. I'm in the same anxious spot that a lot of the rest of us are. I need to be at work, and yet I have a child that needs somebody to care for them, and I'm the only one who can do it. So I don't have better answers for you about how this is going to work as a practical matter. All I can tell you is that the regulations have simply defined healthcare provider and emergency responder and didn't go further than that at this point.
Another question, can you run through a scenario where an employee says, I don't feel good, I need 2 weeks off, and related concerns? What are our obligations as employers to determine if the employee should not seek medical attention?
Well, just to answer that piece of it, I'm not sure an employer is ever in a position to tell an employee to seek medical treatment or not. That's the employee's decision. I think an employer has to assess whether or not the person falls within one of the enumerated reasons for covered leave. That would be number one. And number two would be whether or not it's in the interest of the employer to remove that person from the workplace, whether they choose to seek medical treatment or not. So that's why I'm hoping to get this cheat sheet out to everybody, because I think it will help to be able to say, okay, go back to the list of the reasons why somebody can be out. So somebody says, I don't feel well. So let's see where that fits. They're not subject to a quarantine or an isolation order. They haven't been advised to self-quarantine by a healthcare provider. They are not caring for an individual who's subject to quarantine, and they're not caring for a son or daughter if school's closed. So the only one is if they're experiencing symptoms of COVID and are seeking a medical diagnosis. If somebody says, I don't feel well, I think it's fair to ask that question. Are your symptoms those that are defined as COVID or that are recognized as COVID related? And are you seeking a medical diagnosis? So if they were to say yes, then they may qualify for the emergency paid sick leave, in which case out they go and they take their 80 hours. If they say no, I just generally, I'm so anxious, or I'm stressed out, I just don't feel well, then you're back to the world as it used to be before all this happened. Is this a valid reason for leave? Do they have accrued time? Am I able to let them go at this point? Does it qualify for regular? Because you can't forget about regular FMLA either, because that's still out there. So then you just go through the assessment like you would in any other situation. So I think, it's hard to give a structured answer for this is step one, this is step two. That's what I'm trying to do, because I know that's what everybody wants. I think as best I can do that is to say, step one, what is the situation, and does it fall within those 6 enumerated reasons of the emergency paid sick leave? That's question number one. Number two, does it also fit with the expanded FMLA? If the answer to both of those is no, then you go to, okay, maybe I'm in a situation just like any other request for leave before COVID. Is it FMLA? Do they have accrued vacation? Do they have sick time? Is there a note from a doctor? And you go through your regular policy steps in your policy.
If you're just joining us, thank you, Anne-Marie Storey with Rudman Winchell. We're taking your employment-related questions. I'm Deb Neuman, president of the Bangor Region Chamber of Commerce. Working behind the scenes is Shelley Sun from the Chamber and Karen Sichters from Rudman Winchell. If you have questions, please just comment on the Facebook comments, and Shelley is forwarding those to me. There's a question about, is there an exception for employers with less than 50 employees? What is the breakdown?
There is, and it was a little unclear what that meant. This was addressed in the regulations that just came out, and I just want to get to that. All right, so an employer can, the process is not clear. Let me start by saying that, and the regulations still don't make it clear. There are reasons why a small business with less than 50 can ask for an exemption from the Paid Sick and Emergency Family Medical Leave Act. And they have to meet certain thresholds that they have to certify in some way to the DOL, although we don't know quite how that is supposed to be. But the reason, hold on. The only portion of the sick leave law that they are going to be exempt from is because of the child's school is closed. I didn't say that very well. So let me just read you what the regulation says. A small business is exempt from certain paid sick leave and expanded family medical leave requirements if providing an employee such leave would jeopardize the viability of the business as a going concern. This means a small business is exempt from mandated paid sick or family medical leave only if they have less than 50 employees, and the reason is requested because of the child's school or no daycare. So that's the only reason under the sick leave law and the family medical leave law that they might be exempt. So they're not going to be exempted out if the leave is for the employee's own sickness or they're needed to care for someone else. Does that make sense? So there is apparently an exemption for 50 and under, but only for circumstances where the employee is seeking leave to care for a child or who is out of school, not sick, but a child who's out of school or daycare. That's the only reason. And then there has to be information provided in some fashion to the DOL that hasn't been defined yet to show certain financial impacts on the business that would result from that person being out. So it's not quite as broad as they made it sound in the initial law, which was, it sounded like the exemption was going to apply to the entire act, to all the reasons why somebody might be out. And that's not going to be the case.
Speaking of childcare, another question. With the EFMLA, can it be used? Can it be used intermittently? Example, I don't have childcare for 2 days this week. Can I work 3 and use FMLA for the other 2 days?
Yes, that's a good question. And that is one of the things that was addressed in the regulations. So let me preface that by saying that the use of intermittent is only available for childcare or lack of school, okay? Intermittent cannot be used for any of the other 5 listed reasons under the emergency paid leave law. And when you think about why, it seems pretty clear, because if somebody is quarantined or self-quarantined or has the symptoms or is with somebody else who has the symptoms, you don't want that person in the workplace. So, or by definition, they can't be in the workplace. So there is no intermittent leave, according to the regulations, for any of those categories. But they are recognizing intermittent leave for caring for a child who's out of school or daycare. So that situation you raised is a perfect example. Maybe I can work Monday, Wednesday, and Friday because I have someone to cover me those days, or my spouse is home, but I can't work the other 2 days. And that's when intermittent might apply. It could also apply, it could be days of the week. It could also be hours. It can be in hourly increments. So maybe every day I can work, 6 hours, but not the other 2. And so that would be calculated intermittently.
All right, thank you.
Can I just point out,
Absolutely.
they also say that the employer and the employee need to agree to not only to use the time intermittently, but on what the schedule will be. And they put a specific provision in here. It's almost like a parent talking to 2 children that says, work it out. Basically, we want the employers and the employees to act in good faith, to work this out and not have a lot of fussing about what my intermittent schedule is. And, so I think that's a strong encouragement to find a way to make this work.
All right, I have one for you. You ready?
I think so.
If someone was out with qualifying reason based on the new law, but prior to April 1, am I to assume that they now qualify for this paid sick leave starting on April 1st, but it wouldn't apply if they haven't filed for unemployment? Or if they have applied for unemployment, then it wouldn't apply?
A good question. So let me take that in 2 pieces. If the employee is out for one of the qualifying reasons, but goes out, let's say today, before April 1, they will be eligible for the leave as of April 1. So if I went out today, and I'm working through this just like everybody else, but if I went out today, the law is not in effect. So I think the employer could say, you have sick time, depending on the reason I go. Let's say I'm not feeling well. I can take my sick time between now and April 1. And on April 1, when the new leave law starts, I would be entitled to the emergency paid sick leave starting from, so I get my whole 80 hours starting on April 1. And I could no longer be required to use my own sick time. Let me say one thing about that though, because they also clarified that for the payments that are less than 100% of what I was getting, so when it's like 2/3 of your regular pay, an employer can, with agreement between the employer and the employee, allow the employee to use their accrued time to supplement, to take them up to full pay. Okay, but you can't require that they do that. The employer and the employee have to agree that that's what they're going to do with the accrued sick time. So if the employee says, no, I don't want to use my accrued time, I want to save it for who knows what in the future, then that's the way it is, and they get whatever they get under the paid leave law. Okay. So that was a digression. But so the question is, if I'm out for a qualifying reason now, come April 1, which is only 2 days from now, I would be entitled to the provisions of the law, the whole 80 hours. However, you mentioned unemployment too. If I'm out for a reason that isn't covered as of April 1, then I'm not entitled to that law either. So if, for instance, the situation where an employer has completely shut down because let's say they just can't afford to keep anybody working, they've just closed the doors completely, that is not one of the covered reasons. So if that happens today, as of April 1, I'm not entitled to any of those rights because we're out for reasons that have nothing to do with that law. It's because the employer is not operating. And if the employer is not operating, the paid sick leave law does not apply. But I would get unemployment, or at least I could apply for unemployment. Because unemployment and the paid sick leave are not going to run at the same time. You're going to get one or the other. So if I'm eligible for the paid sick leave, I'm not also going to get unemployment. But if I've been furloughed before the act goes into effect and the employer is just not operating or operating at a minimal basis, I would get unemployment, but not the paid sick.
This is related.
This is great, isn't it?
Wow.
Like, I know it's overwhelming. I know.
What is the employment benefit for an employee who has been partially laid off, so their work hours have been reduced as a result of COVID-19? Is the $600 additional benefit prorated?
Yeah, I don't know the answer. They have
I
to
don't either. That's an unemployment question. We're going to wrap it up here pretty soon because we're using every ounce of Anne-Marie's brain power this afternoon. I don't want to wear you out, but if you've got any questions, just comment on the Facebook Live and we'll try to answer them for you. We'll go about another 5 or so minutes. Anne-Marie, do you want to add anything we haven't talked about yet?
Gosh, there's so much. It's hard to even know where to start with the what people don't know. Just to go over a couple of basics. So the 500 person threshold includes full and part-time people, including people on leave, jointly employed people, and day labor supplied by a temporary agency. So when you're counting up your employees to see if this applies to you, keep that in mind. Independent contractors are not covered, although I understand there is a provision in the SBA, the CARES Act, I believe, for independent contractors and sole proprietors. Which, and again, I think that's going to change a lot of this. Let's see, rates of pay. I mean, there's just so much. I'm not even sure how to formulate, like, where to start if somebody doesn't have a specific question about something. Oh, I see one up there. What was the document we were supposed to? So that was the notice. This is the notice issued by the Department of Labor. That's the Federal Department of Labor, not the State Department of Labor. So you can go on the Federal Department of Labor website and print this off.
Is it easy to find on the website?
Well, I'm also told it's on our resource page, so it might be easier to look for it there.
Okay.
And
daily constant e-blasts.
Oh, right. Well, because we sent this out by e-blast, so if somebody got that, it would be attached to this, or at least the link would be there. This, as I said in the beginning, this must be posted as of April 1. And ironically, since it has to go to all employees and most, a lot of people are not in their offices anymore, it should go out by email or be available on the website or however the employer is getting information out to people. But everybody must have access to that poster.
Well, right after this, we'll find it on the DOL site and post it as a comment, a link in the comments here, so you can get to it quickly.
I mean, I anticipate we're going to continue to get clarification from the DOL as more and more questions are raised and they work through some of this stuff. So obviously we'll keep updating people as much as we can. Oh, there it is.
Nicely done, Shelley Sund in the background. Look at that. Okay. All right, thank you. I think I saw another question. Hang on. Another question for you. We have home care staff whose hours vary and don't necessarily have the same hours each week, and also get paid differential for weekends and holidays. From what I've read so far, we have to figure their average wage for the last 6 months.
All right, so let's go back to the regulations and see how that, because that is a complicated situation. So, all right, so we've got part-time people, but they're not part-time, right? Or at least, all right, so what it says is they're paid, you calculate it based on what somebody gets for their normally scheduled work hours, even if they exceed 40 a week. For employees with variable hours each week, the paid leave is equal to the average number of hours worked per day over the previous 6 months. So that's, looks like that's part of what they have said there. So that's how you calculate that. Part-time is different, but so that's what you would do in a variable hourly situation.
Good. 3:41. Let's wrap up at 3:45. Anything else we want to talk about at this point?
I did want to just remind people that the amended FMLA, now this can get super complicated, but at its very basic level, the amended FMLA is not in addition to the regular FMLA that we are all familiar with and love so dearly. So if somebody has already taken, if you're on a rolling basis and somebody has already taken part of their FMLA entitlement, they will not be entitled to the entire 12 weeks of leave available under this kind. It's a total of the 12 weeks. Not, you don't get an additional 12 weeks for this kind in addition to the 12 that you get under the normal FMLA. And just to complicate matters further, though, because you know that's what we like to do, if there is a reason why somebody would be entitled to main FMLA that is not the same as federal, then they may end up with 12 weeks. That's the same thing we've always been talking about. It's no different. This amendment is only to the federal FMLA, not the main law. So if somebody, it's possible that somebody could qualify under main law and have already taken some leave during this year, but also still get the whole 12 weeks here, depending on the reason for the leave. So again, I think just a red flag, if you've got somebody who has already taken FMLA, just do a closer look at what their total entitlement now will be.
And you mentioned earlier that you're trying to put together sort of a fact sheet.
How much are you going to pay me for that?
I know.
No, I'm just kidding.
If you answer yes to this,
All
go
right.
here. If you answer no, go here.
I am desperately trying, and you know, it's nearly impossible because there are so many unanswered questions, and you know, yes over here and no this way and you know that way, and so but I have a good start. I'm hoping in the next couple of days I can send something out that at very least employers can say, okay, I feel a little bit better. I can look at this and see the reasons why, and at least know, do they qualify here? If not, I go here, and you know, it will be gold if I'm able to do it.
Thank you so much. Thank you so much. I'm sure there are more questions.
Oh, can I answer that one?
Yeah, there it is. From Facebook Messenger, are PCPs required to complete FMLA documentation with the emergency FMLA?
Yeah, well, so the regulations actually did mention that, and because this is an amendment to the regular FMLA, the same certification requirements seem to apply. So if the reason for my leave is my own serious health condition or that of a family member, the employer is still entitled to the medical certification forms that are required under regular FMLA leaves. Having said that, I think there might be some room for a little bit of leeway in terms of timing if the doctors are so overwhelmed that they just don't get it done within the appointed, 7 days or whatever that is. I wouldn't necessarily deny leave in these circumstances just because of that. But ultimately, an employer is entitled to ask for that information if they want to do that.
With reference to you putting together that awesome flow chart, you'll like this. Julie said, if anyone can do it, Anne Marie can do it.
Well,
Agreed.
now the challenge is on, right?
So there you go.
One might have also thought that Anne Marie could get her child to do her homework, and that has not happened successfully. So I'm hoping for better results here.
Yes, I hear you. And then something about Nick says you make the best treats. So
Yes.
must be a friend. Thank you so much for doing this with us this afternoon. And thanks to all of you who watched and sent along some great questions. If you're up for it, why don't we make this a regular deal, maybe once a week, if you're up for it. No pressure.
Absolutely. I mean, stuff changes just from Thursday or Friday is totally.
Yeah.
So
It's really helpful. You're helping a lot of people and we appreciate it. Anne-Marie Storey with Rudman Winchell. I'm Deb Neuman with the Chamber. There's Shelley's son. Can we see you now? Yay. Shelley put this together. This is the first time we've done this.
and I would like to say that Karen is here and has done an
Yes,
amazing job as well.
So thank you both so much. Thanks to everybody who joined us this afternoon. And just stay tuned to Rudman Winchell Facebook, Bangor Region Chamber of Commerce Facebook, our emails, Rudman's emails, and we'll let you know when we plan to do this again. But we'll probably try to get into it. We've been doing this weekly for the last.
Yeah.
Is this the third time we've done this?
The fourth.
Fourth. The first one seemed so long ago, and so much has changed.
And we seem so naive then too. Like,
Yeah.
we'll be back in session in 2 weeks and, everything will be back to normal.
Yeah. So bottom line is stay safe, stay healthy, and we'll get through all of this together. Thanks again. So with that, we'll sign off. And Shelley, we will post this. Where will we post this if people want to see this or send this to their friends?
It'll go on YouTube, but we'll also post it to our website on your information page, the COVID-19 information page. Right, you can access it right from the top of the page. So, yeah.
And that's bangorregion.com.
Yep.
Okay, good.
Thanks, everybody.
Thank you. Have a good afternoon.
Nice too.
All right, take care.